Now to Idaho, where the suspect accused of murdering 4 Idaho students made his second court appearance last hour. We just got new video of Bryan Kohberger in court, straight-faced, not looking at the crowd or the media. He faces 4 counts of first-degree murder in addition to burglary charges, and prosecutors are weighing whether to pursue the death penalty. During the hearing, Kohberger waived his right to a speedy preliminary hearing. Essentially what that means is that the prosecution can take their time, right? So at the end of the day, what happened there was housekeeping. They talked about dates of the next hearing, so there was nothing particularly substantive with this particular hearing. It's more procedural. Hemmer, I have a question for you, a thoughtful question. It's this. With questions of death penalty on the table, if he had committed his atrocious murders, for the sake of argument, he did it for right now, okay, let's just say. If he had done it 8 miles to the west, the death penalty wouldn't have been an option because it's not an option in Washington state. It's only an option in Idaho. Given that he fancied himself, we understand, allegedly some type of, mastermind, and he was getting his PhD in criminology and he could outsmart the system. And in light of the fact that he made so many amateur mistakes that enabled him to get caught, do you see this as the most fundamental mistake he made, or do you see it as a potential bargaining chip that he knew, just like we saw in Florida, just like we've seen all around the country, that a lot of people use it as, well, you know what, I'll plead guilty if you take capital punishment off the table?
I know I'm going to disappoint you, but I don't know the answer to that. And I don't know the answer because I don't know what the motive yet is for why these 4 people were so brutally murdered. In Idaho, however, there are 8 people on death row today. The state has not executed anyone in 10 years. The last inmate to be sent to death row was 2017 for killing a cop in Coeur d'Alene in northern Idaho. Paul Morrow, who we rely on a lot to take us through this trial, he's not going to be back in court until June.
Correct.
June 26th, almost July. This is a 6-month punt of this trial. And what happens during the proceeding when they come back? This could go for 5 days. And both sides will apparently present evidence. And so you will get a trial before the trial, is how Paul characterizes it. And he says the system feels weird to him. And in June, I guess the families have to wait, right? The families have to wait now 6 months before this thing gets into motion. Remember, Kohberger is studying for his doctorate in criminology. Did he commit the perfect murder, or did he just think he was good at it? It seems to be what he's trying to figure out based on the evidence after today's proceeding.
That's right, and I think what Bill is getting to, included in that is the hubris. It's either the hubris of a narcissist or the hubris of someone who just fancies himself larger than life, able to get away with this attempted perfect murder that instead left so many bungling and amateur things in its wake that led the police to, I don't want to say easily, that's a strong word, that so clearly, especially in 2020 hindsight, be able to nab him. That original 19-page affidavit laid out so clearly the myriad of trails that he left. It was more than breadcrumbs, Harris. It was cell phone, it was technology, it was physical presence, it was 12 times stalking those young women, and that was just in the last year. And there were so many more other pieces of evidence. So to Bill's point, if he fancies himself smarter than the system, guess what, you're not.
Yeah, I'm really struck by what you just said. I didn't know that about the 6 months.
Yeah, end of June. That's the breaking news.
That's a long time.
That he's going to challenge the evidence.
Of course he is. And he's going to have time to make copious arguments on his own. I just wonder who it benefits to have more time. It certainly doesn't benefit the families. Right. But how, in the legal scope of things, and you did the interview, and I didn't see it, I wish I had, how in the legal scope of things does that change the case, or does it impact the case? Or is that just kind of how it always rolls, that, judges and people in the legal system are available when they're available, and you just kind of go from there? It's
frankly not infrequent. It's not rare to have it drag on like this or have this kind of, honestly, this calendar doesn't surprise me. I'm not at all shocked by it. No, I'm not surprised. And remember, the burden is on the state. The burden is on the state to prove the case beyond a reasonable doubt, and all the defense has to do.
Do you put in a gag order? What do you do? What happens in those 6 months
Well, so to be clear, if a judge issues a gag order, it would be because they feel that the media is somehow playing a larger part than it should, that the jury pool might be tainted, or that there are things that are being
Is he
thrown
allowed to
out
give interviews?
there. The judge or the defendant?
Kohberger.
The defendant? Absolutely not. I mean, that would be the worst possible advice that his attorneys could give him, would be to
No, I'm just saying legally. You know, we're in such a different day.
Yeah.
Man in his 20s. I believe he's still 28, isn't that right?
Yes.
You know,
28.
Social media changes everything. We don't know. We don't know. And so when you tell me a scope of time like 6 months, it's not the same as 6 months like 10 years ago in a case.
Remember, there's no bail granted, so he's in custody of the state the whole time.
And if he's grandiose, he's also famous or infamous right now.
Right. He thinks he is, that's for sure.
Yeah.
And Jerry, that was part of the trail that he left, was a lot of online presence, to Harris's point, that he fancied himself not only indestructible, but certainly free to be honest, and put forth a lot of details, including after the murder, details that were not yet public, which somehow clearly read as damning.
Right, exactly. Well, so 6 months seems a long time to sort that out, right? And do you know who I feel sorry for? You mentioned the hubris that he was exhibiting. How about the emotions in the community? Yeah. I mean, there's got to be very high emotions among these families, the neighbors, everybody involved. You know, I'm from a tiny town in North Carolina, up in the mountains. If you had a brutal murder like this in little 4,000-person Spruce Pine, North Carolina, let me tell you, people would be apoplectic. I mean, you've got to feel for the community.
So it's just this is all breaking news, by the way. It's just coming in right now from Idaho. So the prosecutor did not object to this suggestion.
To the waiving of the...
Yeah, I mean, is that the way this works?
It gives the prosecution more time to do their job.
It does. I mean, it gives everybody more time.
But last week we had a 19-page affidavit, which apparently had the evidence against him, right, based on his cell phone record, based on the DNA on the knife sheath that was left in the bed behind. Well, we were told, Emily, that was enough information to go ahead and arrest him. Why can they not proceed based on that now? Well,
the threshold for arrest is lower than the threshold for conviction. That's number one. Number two, I feel like this is begging that existential question, Leslie, which is, if a community which is absolutely horrified and rocked to its core by the brutal murder of 4 students who hadn't seen a murder, they haven't seen an execution, they also haven't seen a murder there in that particular town for over 10 years, is the arrest and custody, the custodial nature, is that enough for the moment? Would the community say, you know what, as long as he's in jail right now, we will wait for a successful trial, a successful conviction, if it means a few months longer, right? The arrest is more important than the speedy trial right now, with the potential for it to not go through. And remember, again, the protection is on the defendant in our criminal justice system. So that defendant has the right to waive that speedy trial, and no matter how much we want to see a conviction, that trumps the pace of it.
Oh, absolutely. I mean, yes, this is, you know, horrific for these families. This is horrific for this community, friends and neighbors, and even people who just saw it, you know, on television as well. But I do think, to your point, I do think that you know, some people might say it's a Band-Aid, but it is right now enough to stop temporarily the bleeding in this community from the wounds of these murders, because he is behind bars. Remember, I mean, you had a time where they didn't know who did it, and he was, you know, still on the large, and people were concerned. What about my child? What about my home? You know, not being able to sleep at night. So it gives them some sense of security. And, you know, look, I think speedy trial went out the window, sadly, a long time ago, but it can benefit the prosecution, and what they want is the right person to be behind bars forever or
Got it,
put
but
to
this
death.
Just be clear on this. I don't mean to keep on going on. This is a preliminary status conference under Idaho state law, which is essentially a probable cause hearing. The bar for that's really low. I mean, the bar for that was probably found in the affidavit. I'm not arguing for conviction here. I'm just arguing that if you believe you have the right person, why can you not proceed? That's all.
Right. Okay, thank you. Thank you for that. Excellent questions. We will continue to keep you updated with everything as it comes. Hey everyone, I'm Emily Campagno. Catch me and my co-hosts Harris Faulkner and Kaylee McEnany on Outnumbered every weekday at 12 p.m. Eastern, or set your DVR. Also, don't forget to subscribe to the Fox News YouTube page for daily highlights.